Well, welcome to the last podcast of 2022. And I'm starting our podcast today, Exhibit A, because I was ridiculed by none other than our producer, David Lindley, who got all these clips of me going, "We are on. We are on. We are on. We are on. Okay, we are on. We are on." Okay, we're not going to do that. Yeah. Okay. So I want to be very careful this year, as to how I start these things, because I don't want to repeat next year.
You need some new catchphrases.
Yeah. Let's start. Or welcome to the Exhibit A podcast. This is Don Schweitzer with Mane Hakopian, and we're going to talk to you about the law. How does that sound, David?
Perfect.
Okay, great. Okay. So anyways, before we get into our legal analysis, it is the end of 2022. And doesn't it feel good to put an end to this year?
It does feel good. Yeah.
See, so I think we all probably could speak differently about the past year. This was a hard one for me for a variety of reasons. I'm glad to put it behind me, I asked everybody in the office to put together a list of 3 things that they could improve upon in 2023. And the reason why I did that is this time of the year, I always try to look at what I accomplished and what can we do further. And I kind of have that habit, and I think it might be beneficial for people to do. But 2022 was a milestone, or it's because we're coming up now on the 20-year anniversary
Of the firm.
Yeah. And so March of 2023 will be our 20th year. That's where we set it, and we already started kind of like celebrating it because we're closing in on it. I always think about, okay, if you compare the age of the firm with the age of a person, now we're talking about a 20-year-old, right? 20-year-old could vote, out of the house, hopefully.
In college.
Maybe in college. Can't drink yet, though. Okay, so we have to wait for one more year before it's a drinking firm.
Depends where you live.
That's true. That is true. I didn't think about it. Are there any states where you could drink under the age of 21?
I think the U.S. is pretty standard.
It used to be. You don't know about this, but there were many states that had the drinking age at 18 when I was a kid. Growing up in Chicago, my friends, not me, I swear to God it wasn't me, but they would get on their cars and they'd drive to Wisconsin to drink for the night and then come back into Chicago and stuff. Then when I was in the military people get to drink as soon as they're in there. So they could be 18 years old and they're drinking. Anyways, so we're not of age yet, okay, but we're getting there. So that's good. Okay.
It's also, when I started here, we were celebrating 15 years, so that means I'm
Holy
going
cow.
on to my 5th year.
Oh my God, that's right. I was going to ask you that. Yeah. So we like to celebrate our milestones and stuff, and 2023 is going to be a continuous celebration because for me, personally, it's a really big deal. Yeah, I like to joke and I tell people the longest I've ever held a job was 8 years. You're 3 years away from meeting, my prior time with a job and stuff. But I went from job or profession to profession, and 20 years, I always think that means something. And I could say this without a doubt that you learn, right? Being a family law attorney, as long as I have been, I've really had a good study on people. I think you would think, right? It's a study of human behaviors. You see certain patterns among people.
Definitely.
And you do get better, hopefully, as time goes on, but you never get perfect. You still make mistakes. It's a great profession, very tiring, but it's something that if you're into it, you're really into it like we are. Yeah. So the only other comment I would say about 2022 is we have the blessing at the end of the year. Every year we got the Rose Parade coming up, and we don't have the weather that they've been having back east. So thank God.
I know. We get a little rain and people go crazy. So.
Which is hilarious. I mean, for people like me, where I grew up in Chicago, when I see winter pours out here, they drive like maniacs, right?
Right.
Where David comes from, they don't have rain. They just have sunshine the whole year long.
They
Australia.
do have reptiles and insects and things that could kill you. So.
They don't get in front of your car, though, hopefully. Okay, so we are talking today about an appellate court decision that I wanted to talk about because I think it has a lot of implications for clients that we have. And there's a lot of folks that might be viewing this podcast and want to know more about the move-aways and domestic violence and how they interplay and stuff. So this case is going to be interesting because of the fact that we're going to see, I'm not going to give away the punchlines here at the end, but we're going to see how the interplay between domestic violence and move-aways are. So having said that, why don't you set up the facts? What's the name of the case first?
The name of the case is Ramsden versus Peterson.
Okay, and a California appellate court decision.
Yep, Santa Barbara County.
Okay, so what do we know about the facts?
So the facts are as follows. We have a husband and wife who have a daughter, and it didn't really talk about the custody arrangement, but I believe that they had pretty equal time, but mom had primary custody of the daughter. So the daughter is HP. They don't use her actual name. So at some point after they start sharing custody, a mom files a request to move away from California to Oklahoma, and the court denies her request. Mom was newly married. She wanted to move away. Court says no.
Okay, and then what did the court do?
Then
It granted her primary custody, right?
you're right. So she first wanted to move away to Arkansas. That was her first request in 2016. The court said no, but it gave her primary custody.
What's interesting to me about this decision is it doesn't say why the court was making the rulings that it made. So, for example,
Right.
why did she get primary custody?
Mm-hmm.
And then after she got primary custody, why did the court deny her move away?
Right.
Yeah.
They sort of talk about it later on, but
That
not
seems like it's
really.
bootstrapping to me, and I'll explain later on. But I mean, at the beginning of the decision, it just says the court said no.
Right.
Right?
It just says no, but she was granted primary custody, physical custody. Then she makes a second request to move to Oklahoma. The court says no again.
So this lady's like moving around, right?
Yeah, she's
Arkansas, Oklahoma.
Yeah, she's trying to move with her new husband.
Right, right.
He was stationed in Oklahoma. She was trying to move. They said no again.
Fort Sills, Oklahoma. Horrible place to be stationed, but go ahead.
Then about 4 years later in 2020,
She gets smart and she decides to go to Illinois. No, go ahead.
there is an incident with dad and his new girlfriend. So the dad's girlfriend calls up the mom and says, just want to let you know that dad and I were involved in a physical domestic violence situation, and dad assaulted me. This is his girlfriend telling the ex-wife, and he also drove intoxicated with a minor in the car.
Some huge things going on here,
Mm-hmm.
you know. So number one is that this court is just denying her request for move-aways before these incidents play out, even though she's the primary caretaker.
Right.
And we don't need to go through all of the factors that a court has to consider in moving away, but the decision is silent, you know. So what are some of the things the court normally are going to look at before it grants or denies a move away?
So, I mean, one of the biggest things is what the current custody arrangement is like. The more custody you have, the better your chances are of being allowed to move away with the child.
Yeah, a primary custodian has the presumptive right to move away, right?
Yes.
Okay. And the distance?
The distance of the move, I mean, it's really just a best interest analysis with some additional factors that go into move aways. So it's if you're trying to move away to San Francisco versus, you're trying to go to a different country, that's the distance is going to come into play, and some other factors like that.
Yeah. So when we talk about the court of appeal really didn't specify what was going on at the beginning. We can make some deductions here, right? We could say that it's possible that the child had a strong bond with the father during those early stages. At least the court found that to be it was an equal bond or something, because that's another factor is what's the relationship like, and would it be detrimental to the child, if the move was away. So those things might have happened. They probably happened early on if we're giving everybody the benefit of the doubt. But now, boom, we hit this fact pattern where girlfriend calls
the
ex-wife and says, guess what? I want to be your best friend now. We used to sit around and talk badly about you, and I was the knight in shining armor, and I was the one who was always there to rescue. But guess what? He is as much of a jerk as you thought he was. He's been committing domestic violence on me. He drinks, and he even drinks, and he brings the child along with him. And heaven forbid,
Hit
she
a
gets
car.
got into a car accident with the daughter in the car.
Right.
And we've had some of those in our caseloads. So I just thought that was, when we're talking about pattern of behavior, sometimes we see the ex-wife getting along with the new girlfriend because the new girlfriend now is the ex-girlfriend.
They team up.
Yeah,
Right.
yeah.
Right.
It's the worst nightmare in the world for this guy. So they're talking, right?
So wife hears this and she files an emergency request to have exclusive custody of the minor, and The court surprisingly denies the request, extends the current visitation at the time, and again doesn't say what the visitations were with the dad, but it keeps the custody as is, but there is a pending child welfare services safety plan. I'm not sure what that is.
It was interesting how they called it, Child Welfare Services. This is California. Did the Court of Appeal get it wrong, or is there some other department out there?
I'm assuming another department.
Because we call it the Department of Children and Family Services in LA.
Right.
So maybe county to county. I didn't know that, so I saw that as well. Yeah.
Right. So they said that plan should be followed pending a hearing later that month. So it kind of deferred the decision to the Department of Child Support, or the DCFS or CWS.
It was probably like the caseworker came out and didn't really file a petition, because otherwise the matter would have been in dependency court.
Right.
So the caseworker said, okay, can we get a voluntary agreement here that you're going to do X, Y, and Z? Right?
Yeah,
okay.
probably.
Okay.
So there was an actual hearing for the custody request, and what the court said was they're going to appoint minors counsel for the child to make recommendations when they come back the next time. So everybody agrees to minors counsel, and that minors counsel was supposed to make recommendations.
Okay.
So pending the next hearing, I believe dad's time was reduced temporarily in order for the child to get stabilized again, and he agreed to this. And this happened after minors counsel was appointed.
Right.
So the child said she didn't feel comfortable going to the dad's residence.
So the child's telling minors counsel this,
Right.
and then minors counsel is reporting this to the court
at the next hearing, which she was asked to do. And she asked that the court, so the minor told her counsel that she wanted to temporarily change the custody arrangement in order for her to sort of adjust to what happened with the dad, driving drunk while she was in the car. So this was, my understanding was this was temporary, pending whatever else happened. So
we should probably pause here a little bit for the people that aren't in family court like we are. Minors counsel is an attorney that is assigned to represent children. So when there's a custody dispute between mother and father, the child's always in the middle, and the courts deem it necessary a lot of times to appoint counsel to do what's best in the interest of the child, not to do what one person thinks is their rights or anything like that. Let's focus on the child and the child's rights, where this child should be. And that's what happened here. So this child gets minors counsel. Minors counsel goes into court and addresses the court and says, this is what should happen because the child is telling me that she's not comfortable right now.
Right.
Okay.
Which is very common, right? We see this all the time where courts give specific instructions as to what the minors counsel is supposed to be making recommendations for.
And these facts right here will play out later on in the decision. So very important that we kind of put a footnote here that, or not a footnote, we put a tab on this, is that this happened, where the minors counsel is addressing the court. So, okay, and then what happens next?
Then it's a little fuzzy as far as, I wasn't really sure if this part of the hearing ended and then mom filed another request.
I think
for
that's what
move-away.
happened.
Okay.
Yeah.
So mom then files another move away request in 2021. And where's she trying to go to this time?
Illinois. I told you she's getting smarter.
Yeah.
She's going to the great state of Illinois. Why? Because I think her husband, I don't know if he was still in the military at that time or what, but
I think that's where he was then. Yeah.
I grew up over there, and I can't. Why the Army's not in Illinois? I don't know why he was over there. So go ahead.
So yeah, she files another move away request, and there's a hearing on the request, and a few things happen procedurally that are important for the court's decision. So one thing is the parties agree, they stipulate to take judicial notice of the entire case file. So the husband agrees to this, and part of the case file included that CWS records, the safety plan that was put into place by the department.
And why do judges love when that happens? When people stipulate to take the whole file into evidence?
Because all of that then comes in, and you don't need to have a lengthy hearing to get certain things admitted, right?
Yeah, and over to hearsay objections, because
right.
the Sanchez, the case of People versus Sanchez would kick in with this, and you'd have a lot of problems with reports like that. But when people stipulate, It's like, cool, I get to look at everything, and you can't later on object and go up on appeal and say that I inappropriately looked at things.
Right.
Sometimes it's usually the smart thing to do, though. I mean, we like to be advocates for our clients and try to interfere with damaging evidence that's coming in. But the way it always plays out seems to be that the more transparent, the better for the court to really see what this is all about.
The husband later tried to revoke his agreement, but the court denied his objection.
Too late.
Overruled his objection.
Okay.
Right. I wonder I think he had attorneys.
Yeah, I think so.
He had counsel, yeah. Then so the hearing's going on mom's move away request. And one of the other things that happens, which is important, is the dad tries to stop the minor's counsel for the child from making custody recommendations. And the court and the mom said, no, your objection is untimely since we had already agreed and stipulated that counsel could make recommendations. And the court agreed with the mom.
Right.
Then, obviously, the girlfriend, I believe, testified about the domestic violence incident or the ex-girlfriend between her and the dad, and talked about, and the dad discussed, he admitted to drinking alcohol and driving, but he said he wasn't intoxicated.
Right.
He said he drank and he drove and he hit a parked car, but that he was, in fact, not intoxicated.
Right.
And he also admitted to having verbal and physical altercations with his ex-girlfriend in front of the minor child as well.
So you definitely got a change of circumstances here. Some big things that are happening. You got fighting with his girlfriend in front of the child, somebody reporting domestic violence. You got drinking and driving, and you got an accident with the child in the car. There's a lot of things now that the court is seeing that didn't see way back when mom was asking for the move away.
But what's interesting is the court, should I just
go ahead?
Reveal the big finale that the court ended up this time around granting mom's request to move away. And it's interesting that the court, in its reasoning, said it didn't rely so much on the incident that happened with the drinking and driving.
I thought that was fascinating.
Right.
Yeah.
But it relied more on the fact that mom was now married to the same husband for many years, and they had a more solid foundation.
Okay, incredible. There's nothing in the appellate court decision about their relationship, right? And how would you really know? I mean, they could still be people that fight with one another, but nobody would know. But this court is saying, yeah, they've been together even longer, so, the relationship is stronger, so that's a significant change of circumstances where I'm going to allow the move away.
That was one of them.
Okay.
The other one was while the minor child was initially bonded with the girlfriend, the dad and the girlfriend were no longer together. So this also played a role in the request being granted.
So on one hand, mom's relationship with her husband's stronger, so there's more stability in the house. Father, on the other hand, has had a weakened stability. His stability in his health is less because his relationships are, down the tubes. Okay.
So those were really the two big factors that the court pointed to, plus also, the drinking and driving and the domestic violence with the girlfriend. But then the dad appealed, and he was appealing three different. He was saying the trial court made three specific errors. So one of them was the minor's counsel shouldn't have made custody recommendations. The second one was the minors that the court admitted, or the court relied on hearsay. And then the last grounds for the move away or for the appeal was that the court didn't apply, or the court erred when it granted the request under a best interest standard because it should have used the changed circumstances standard.
And there was insufficient evidence to support mom's request.
Right.
Okay. So the Court of Appeal took it all under submission, and drum roll, please, what happened?
And the court agreed with the trial court. It denied the appeal, and it went through each of the different grounds for appeal and said, you're wrong on each of these grounds. So it upheld the decision for the move away. And so in explaining discussing the first ground, the custody and visitation recommendations, the court goes through the family code and talks about how, like Dawn, you were just saying about how the court has the ability to appoint private counsel, minors counsel, to represent the best interests of the minor child. And as part of this role, the minors counsel is able to present evidence, introduce and examine their own witnesses, present arguments, and basically do a lot of the things that regular attorneys can do.
But father's saying, and this is an argument that I've heard a lot. I might have made it a couple of times prior to the law changing. Justices, your honors. But what happened here is that this trial court allowed her to testify, minors counsel to testify, and I never had an opportunity to cross-examine her. I mean, she gets in there and she starts talking about what the child said, which is hearsay, and saying all these things, and I'm stuck holding the bag because I can't prove her wrong. I can't call minors counsel to the stand. That's wrong, Your Honor. What did the Court of Appeals say to that?
I think they said he stipulated.
Well, he stipulated to the recommendations, but I don't think you even need to stipulate to that because the code says that minors counsel gets to make recommendations.
Right.
Here's the thing that I picked up on this. Sir, she never testified.
She never testified,
She
right.
was just arguing her case.
So the second grounds for appeal was that the court permitted minors counsel to rely on hearsay, and the court kept this pretty short. All it said was this presumes that minors counsel testified, and she didn't.
Right. So the trial court didn't take in hearsay evidence. She was just arguing her case.
Mm-hmm. And then the last grounds was the move-away request that the court should have used the changed circumstance standard, and it applied the wrong test. And the court said, no, you're wrong because they're one and the same, essentially, which is something we hear all the time. So the court explained that once there's been a finding that a certain custody plan is in the best interest of a child, the court doesn't revisit that. Instead, what the standard is, you look at to see whether circumstances have changed so significantly that a different plan would be in the best interest of the child. So you're not re-examining that it's in the best interest, but seeing if there's been a change in the circumstances where a different plan would be better for the child.
And in this case, there was.
In this case, there was, and the court did not abuse its discretion, and it reasonably concluded that the move away advanced the child's best interest.
Right. So, I mean, some major things here when I ran over this. I think we've pretty much discussed all of these things, but this case is a good one for understanding how minors counsel could be very powerful in these cases because, now we have a new argument when you hear the thing, well, she's testifying. Well, she's not testifying, counsel. She's just arguing. You know what I mean? And if the trial court is wise to this, the courts are going to say, well, I didn't take that into consideration. I took into consideration something else like the relationship was stronger, okay?
Right.
All right. All right. We don't know, why her request was denied twice, right? But we know that we could pretty much deduce that there was some type of a relationship with father and stuff, with this child. And, the circumstances weren't nearly as bad as after the violence occurred. And so that just leads to show that domestic violence or accusations of domestic violence or abuse, even against a third party, can make all the difference in the world, right?
Right.
Because the courts are supposed to look at, the welfare of the child. And if there's evidence that the child's going to be in a household where there has been domestic violence, which is why the girlfriend took the stand and testified, that could be a factor. That could be a factor to lose custody right there. So, people need to be careful getting into new relationships and how that's going to impact custody.
Right. I didn't catch this whether the girlfriend filed for
restraining order,
whether that was granted.
Yeah, wasn't in there.
And I wonder if this incident never happened, whether mom would have even tried to file for a third move away. She probably wouldn't.
Yeah, I mean, it wasn't for the phone call. So, ex-girlfriends out there, fight for those kids. Help. That's really what happened. She's the hero of the day.
Right.
Yeah.
Right.
So, and we also know, I've said this 2 or 3 times, that minors counsel's argument is argument, and now they get a lot of latitude because they get to make recommendations, and the strength and weaknesses of parties' relationships as a reason for modifying custody. I mean, we got an appellate court decision now that we can rely on that. That is a very interesting one. In the future, I would love to challenge somebody on that. You know, it's
right, because the dad, all he said was, there's just been a passage of time, nothing else has changed, and the court said, oh no, mom's relationship grew stronger because now she's been with this guy for over 3 years.
So why do we get divorces when people have been together for 50 years?
Right, that's a great point. Yeah. So her bond with her stepfather grew stronger while his dad's relationship with his girlfriend weakened.
Yeah. I'm just going to assume that there was maybe some evidence of that and the appellate court didn't really kind of flesh that out or something. I hope that was the case. So cool. Great decision.
Yeah, it was a short one, but a lot packed into it. So.
Yeah, good. Well, good job. And I look forward to doing more of these with you in 2023. Have some fun reading cases and educating people.
Yep, definitely.
Cool. And thank you for joining us this year, and we'll see you all in 2023.